Hey there, I'm John Strohmeyer with Strohmeyer Law. In today's live stream, we're answering a number of your questions about probate here in Texas. Now, I'm an estate planning and probate attorney here in Houston, Texas, helping clients leave no unfinished business if they come to us before they pass, or helping families clean up what loose ends are left after somebody has passed. I am a lawyer, but I am not your lawyer. So these answers are general in nature. Make sure you talk to your own advisor when it comes to getting advice about your particular situation. So, with that, let's get to our first question about probate here in Texas. Now, kind of a basic question. Do I have to go through probate in Texas? And the answer is, well, probably you're going to have to do something. Probate can mean a number of different things. There's a lot that goes through this. People have bad ideas about what probate is and what it means based on states like California, New York, Florida, where it can be expensive and time consuming. Texas focuses on its independent administration. This has been a feature of probate here in Texas for generations. It basically allows an executor or an administrator to administer and do the work needed to clean up a loved one's estate without a lot of court oversight. Typically, we're only going to go to court once for a hearing that lasts about 5 minutes. So, what does that mean, John? Do we actually have to do probate here in Texas? Well, let's think about what does this actually mean? Probate means that we are verifying who the beneficiaries or the heirs of an estate are, taking care of any remaining debts, and then passing out the remaining assets to those who are entitled to them. It can be difficult or it cannot be difficult. The part that is a yes, if you have a last will, you're going to have to file that will with the local county clerk. This is a state law that says once somebody has passed, the state should hold on to that last will. It ensures that everybody who wants to know about a last will can actually see it. It's not being hidden in somebody's desk drawer. The part that's a maybe. Well, do you actually have to go in front of a judge and get an answer saying, yes, this is the person who is named in the will as the executor. This will is official, it is valid. We need to administer the estate. There's a lot that can come out of that. Sometimes we don't actually have to do anything. If you have transferred all of your assets using beneficiary designations, or you've transferred real property using transfer on death deeds, there may not be an estate to administer. We may not have to do anything. The next step up from that, we think about a muniment of title. This is a proceeding where we are filing the last will. We're getting a court order saying the will is valid, but we don't need to have a formal administration. So no executor or administrator will be appointed. We're just going to use that court order to say, to whomever has custody of an asset in the decedent's name, this court order and a copy of the will tells you who's entitled to it. We're not going to do any more formal administration. Now, if we've got more work to do, filing an estate tax return, taking care of any remaining debts, dividing up assets that don't divide so easily, this is where we may need a formal administration, even if there is a will. And so what you should hear, sometimes you're going to need to do a full probate. Sometimes you may not have anything left to do. It will depend on what assets are in the estate, who the beneficiaries are, what work just needs to be done. Let's go to our next question. How do I find out if I'm named as a beneficiary in a last will? Well, this can be very difficult if you don't know if the will exists. So, how can we even figure out if a will exists? One, maybe you have talked to the person who has passed before they passed and they told you there's a will. Once somebody has died, Texas state law requires that the last will be filed with the local county clerk. From there, you, me, anybody can go check the county clerk records for wills that have been filed. Even if there isn't a probate proceeding, you should be able to pull up in Texas and see if the county clerk has that original last will. Again, the reason the county clerk is entitled to this last will, and the reason state law requires that the will be filed with the county clerk, is to ensure that everyone knows that there is a will. So it can't be, somebody can't just take that last will and hide it in their desk drawer because they don't like the provisions of it. State law requires that that last will go to the county clerk so everybody can see it. Now, once you've done that, if there is a last will, this gives anyone, a beneficiary, a creditor, someone down the line, the chance to review the will and see if an administration needs to happen. The will has to get filed. It doesn't necessarily have to go through probate, but it may make sense. If there are assets of the estate and more debts, sometimes we'll say, look, this is not the beneficiary's job to pay money to an estate planning attorney like me to take them through probate if I'm going to end up with most of the money. If it's a small estate, my fees may eat that up. There may be other debts out there. Similarly, a creditor may say, look, we're owed $10,000 by the estate. We're entitled to this money from the assets of the estate. The creditor may want to push through a probate so that they can get compensated on their claim from the estate. So, whether you're a beneficiary or even a creditor of a will, checking the local probate records is a great way to see if you've been named in a will or if there's any procedure going on to administer the will and get the assets to the creditors and the beneficiaries. Let's go to the next question. When do I get my inheritance? Who can I go to for help if this is taking too long? Well, here in Texas, probate is generally easier than it is in a lot of other states. New York, Florida, California have longer processes that also include fixed fees for the executor as well as the attorney assisting the executor. Texas has a feature called independent administration that speeds things along. So, how long does it take? It's going to depend on the specific type of administration that's happening. If you're using a small estate affidavit because the estate was, as the name implies, small and there wasn't a last will, it could take a few weeks to maybe a month or two for the paperwork to get filed and for the local probate court or county court to approve that small estate affidavit. If you're looking at a muniment of title where you're going to have the will admitted to probate but not have a formal administration, again, you'll have a few weeks to get the paperwork filed. You'll have to wait for a probate hearing, which will take 5 to 10 minutes, but you're still waiting in line to get that hearing. And then you'll get the order right after it. So, muniment, you could be done in a few months, with most of that time spent waiting for the court to have the hearing. Finally, if you're looking at an estate administration, you're probably looking along the lines of 3 to 6 months from start to finish, filing paperwork, waiting for a hearing, and then 2 to 3 months of on and off work, collecting assets, resolving remaining debts, and then making distributions to those beneficiaries. So when you look at how long does it take, it could be anywhere from a few weeks to a few months, and that's assuming everything's going smoothly. Now, if somebody files a lawsuit, they want to contest a will, they don't think they're getting their fair share, it will take longer. And that's when it could take, months if you're lucky, years if you're not, to get a resolution. What happens then? How can you get help? If you're looking for help, what you'd want is a litigator, somebody who regularly fights over issues like this. You don't want somebody who hasn't dealt with probate issues before, because this is going to be a situation where you want to make sure that you're getting the right help and people who understand how the probate process works. Not everything is the fault of the executor or the administrator. Sometimes it just takes longer to wait for a court hearing. Other times, things beyond your control could be slowing things down. Doesn't always mean you need to pick a fight. So, how long will it take? It depends on your specific circumstances, but expect anywhere from a few weeks to up to 6 months, typically, for an estate to get really fully resolved. Let's look at our next question. So, when is probate not necessary in Texas? This is something that happens occasionally. We look at an estate and say, hey, there's just nothing for us to do here. We may need to do one or two little things to collect assets, but there's not really a whole lot to do. Probate covers a lot of probate can cover a lot of work, and typically we think about it in 3 ways. One, making sure that if there's a last will, we've had it admitted to probate, meaning it's been verified by a court and the judge has said this is the will. That's one way that something goes through probate. Answer two, if there's any sort of administration, there's an executor or an administrator of the estate who's collecting assets, resolving debts, and then making distributions to those final beneficiaries or heirs. Finally, probate can encompass work outside of the court system. This could be doing work transferring assets using beneficiary designations for something like a 401k or an IRA. It could also be ensuring that you've retitled property, such as a house or a ranch, using a transfer on death deed that's been filed before the person passed. Just making sure that everything's been put away and you've transferred title. You may also use things like transfer on death deeds or heirship forms to transfer title to cars or trailers. Now, what does this mean? When could there be nothing to do? Well, we want to make sure first there are no debts left. If there are any creditors of the estate, they may say, look, we want to get paid. We want to make sure we get paid from the assets of the estate. Second, there may not be any reason to do something in probate if there are no assets to transfer. So if you've used beneficiary designations or transfer on death deeds, everything may have already been transferred. Finally, if there aren't any questions, if nobody's contesting a will, if everybody agrees this is what we're entitled to, again, probate may not be necessary. So the formal aspect of probate, of going to court, getting a will admitted to probate, we may get beyond that. Generally speaking, though, the kind of larger version of probate, of winding up final affairs, filing final tax returns, that may happen outside of the court system. But we generally think about that as winding up someone's affairs, and that generally there's something to do when somebody has passed. Let's take a look at our next question. Now, my dad has willed us his house, but his new wife, my stepmom or stepmonster, is already living there. Can we kick her out? Now, the answer to this is pretty clear. No, you can't. The Texas Constitution provides a constitutional homestead right to the surviving spouse. They get to live there rent-free for the rest of their life. Nobody else can kick them out, and you can't sell the property out from underneath them. The other side of this is they don't get to live there without any costs. They will have to maintain certain costs of, keeping the house up. They're going to have to pay taxes on that house year to year. If there are any mortgage payments outstanding, they'll have to pay the interest on that. What does this mean? It means that the people who are going to take the house later, even if dad left the house directly to you, you won't be able to use the house until stepmom has passed away or she has moved out of the house. This means that you may be on the hook for paying for a house that doesn't belong, or that it may belong to you, but stepmom gets to live there. What do you do in that case? I've been on both sides of this. I've had clients who are the stepmom living in the house. I've had clients who are the kids who should have owned the house. Ultimately, it ends up prompting a settlement between the two sides. How can we make sure that mom could either get out of the house and get something for her right to stay there, or how can the kids transfer it back to the stepmom so that they aren't left holding the bag for this? Again, every situation is going to be different, so it'll depend on who owns what. You're not, as the non-surviving spouse, going to be able to kick the surviving spouse out of that probate homestead. The surviving spouse has that right, and it's a fairly strong right. So look for a way that you can settle things between yourselves. Let's go to our next question. I don't live in Texas, but probate is happening there. Do I have to come to Texas at all? Well, if you're not the executor or the administrator, you may not have to show up at the courthouse at all. Generally, witnesses, beneficiaries, or heirs don't have to show up to the hearing. So we have a self-proving affidavit where witnesses to the last will, if their testimony, if their witnessing of the last will has already been witnessed by notarized, their signature has been notarized when the will was signed, they probably don't have to show up to the hearing at all. If you're the beneficiary of a will, you probably also don't have to show up to Texas to be part of a hearing. It may make it easier for the executor or the administrator of the estate if you're there to help them clean up. But the paperwork, mostly at this point, can be done from anywhere. You're going to receive your assets from the estate subject to administration. So after paying debts, making sure everything's wound up in terms of tax bills, you'll get your share. This may be something as simple as a check or having cash wired to you, which can happen anywhere. If you're going to receive a share of real property or real estate, well, you don't have to be here to receive it, but know that you will have an asset in Texas that you need to take care of. Other than that, you probably don't have to show up here in Texas. You're waiting for the executor to do their job and then transfer you the assets that you're entitled to as your share of the estate. If you're the executor or the administrator, we've had a number of clients who don't live in Texas and don't have to show up here because they've appointed us as a resident agent so that they don't have to show up. And then they can appear at the hearing virtually. They can show up by Zoom in a lot of our Texas counties so that they don't have to not only go down to the courthouse, but even be physically in Texas. So even if you're not physically here in Texas, it doesn't mean that you're going to have to show up in Texas. There are some cases where, look, just dealing with things, it's easier to be here on the ground, but there's not a requirement. And let's go to our last question of the day. What should I do to prepare to meet with a probate attorney? So, in the case where someone has passed and you're looking to start wrapping things up, you're going to want to meet with an attorney to get their help on how to get everything wrapped up. So here's some things that you want to think about. Before that first meeting, you want to know, is there a last will and do you have the original of that last will? If there is a will, that's going to direct who's entitled to property. We also need to have the original of that last will because probate is a lot easier if you do have the original document. There'll be more questions about whether, what we need to do with that last will based on what's in it, but we won't get into that today. Just know having the original will and being able to provide it to the estate attorney is going to be thing number one. Number two, who all is going to be involved in this probate? So we're thinking about surviving spouses, children, other beneficiaries of the estate. We also want to know, who are the other advisors? Was there a CPA, a financial advisor, a banker, insurance advisor, maybe a business partner? Who are the other people who are going to be affected by the administration of the estate? May also have some insight into where things are located. Which brings us to the next thing. The biggest problem we have in probate is finding all of those assets. So to the extent that you know where assets are and what that decedent owned, you'll want to know that and be able to bring it. It helps map out the work that will need to be done. If all the assets are at Chase or Bank of America or some other bank, obviously it's going to be a lot easier than if we're going to go on a treasure hunt trying to dig up the backyard looking for bars of gold that have been buried there. So to the extent that you know where things are, that will help. To the extent that you're the person watching this thinking about what you need to do for yourself, have that good list of assets. Finally, just the other things that may need to be done. Was the decedent beneficiary or a trustee of a trust? If so, bring a copy of the trust as well as any known issues with the trust. Were there any debts that we need to take care of? This could be paying off a mortgage, paying off credit cards, or tax debts to the IRS or the county for property taxes. Just knowing what other issues are out there will help your attorney get things in line for you. So with that, we're at the end for today's live stream. If you've got any questions or things you want us to look at next time, please make sure to drop those in the comments below. Thanks so much for watching. We'll